Recording of evidence by court of session. The recording of evidence is crucial stage in every criminal trial because the judgment of the court is based upon the evidence presented by the prosecution and the defense. In trials before a court of session, which generally deal with serious offenses such as murder, rape, dacoity, and other grave crimes, the law requires a detailed and systematic method for recording evidence. The purpose of recording evidence is to preserve the testimony of witnesses accurately, ensure fairness in the trial, and provide a reliable record for appellate and provisional courts. Since session courts deal with serious offenses carrying severe punishments, the procedure for recording evidence is more elaborate than that followed in many proceedings before magistrates. Legal provision. The provisions relating to the recording of evidence by a court of session are contained in section 348 of the BNSS 2023, which is corresponding to section 276 of the CRPC 1973. This section lays down the manner in which evidence is to be recorded during the trial before a session court. Object of recording evidence. The primary objectives of recording evidence are to create an accurate and permanent record of witness testimony, to assist the court in determining the guilt or innocence of the accused, to ensure transparency and fairness in judicial proceedings, to facilitate appellate and revisional scrutiny by higher courts, to prevent disputes regarding the statements made by witnesses. Procedure for recording evidence by court of session. Recording during examination of witnesses under section 348 of PNSS 2023. The evidence of each witness shall be recorded as the examination proceeds before the court. The recording takes place simultaneously with the examination, cross examination, and re examination of the witness. Recording by the presiding judge. The evidence may be recorded directly by the presiding judge himself. This ensures authenticity and enables the judge to accurately capture the testimony of witnesses. Recording by dictation in open court. The presiding judge may dictate the evidence in open court, which is then recorded by an authorized person. Recording by dictation ensures that the evidence is captured under the immediate supervision of the judge. Recording under the judge's direction and superintendence. The judge may also direct an officer of the court to record the evidence under his supervision and control. Even in such cases, the ultimate responsibility for ensuring the correctness of the record remains with the presiding judge. Form of recording evidence. Narrative form. Ordinarily, evidence is recorded in narrative form. This means that the testimony of the witness is written as a continuous statement describing the facts narrated by him. Narrative recording is generally preferred because it facilitates a smooth recording and understanding of the witness's testimony. Question and answer form. The presiding judge has discretion to create any portion of the evidence in question and answer form. This method is often adopted when precise wording is important. The testimony involves technical matters. Contradictions or admissions need to be accurately preserved. The court considers it necessary for the end of justice. The question and answer form provides greater accuracy and helps in assessing the credibility of witnesses. Signature of the presiding judge. After the evidence has been recorded, it must be signed by the presiding judge. The signature serves as authentication that the evidence has been correctly recorded and forms part of the official judicial record. Formation of record. The evidence so recorded becomes an integral part of the case record. The recorded evidence may subsequently be referred to during final arguments, at the time of judgment, in appeals, in revision proceedings, in review of judicial findings by superior courts. Importance of proper recording of evidence. Proper recording of evidence is essential because foundation of judgment, the findings of the court are based primarily upon the evidence recorded during trial. Protection of rights. It safeguards the rights of both the prosecution and the accused. Assistance to appellate courts. Higher courts rely upon the recorded evidence while examining appeals and divisions. Prevention of miscarriage of justice. Accurate recording minimizes errors and prevents wrongful conviction or acquittal. Preservation of witness testimony. It creates a permanent and reliable record of the statement made by witnesses. Case law. State of Kerala versus Rashid 2019 13 SCC 297. The Supreme Court emphasized that proper recording of evidence is indispensable to a fair criminal trial and forms the basis of judicial decision making. Muhammad Hussain at the rate Zulfikar Ali versus State Government of NCT of Delhi 2012 9 SCC 408. The Supreme Court observed that procedural safeguards relating to the recording of evidence are integral to the guarantee of a fair trial under Article 21 of the Constitution of India. Importance or significance. The provisions relating to recording evidence before a court session ensure accuracy, reliability, and transparency in criminal trials involving serious offenses. They help preserve the testimony of witnesses in an authentic form and strengthen public confidence in the administration of justice. Since sessions courts deal with grave offenses carrying severe punishments, strict adherence to these provisions becomes essential for ensuring fairness and preventing miscarriage of justice. Conclusion. The recording of evidence by a court of session is governed by Section 348 of the BNSS 2023. The evidence may be recorded by the presiding judge himself by dictation in open court or under his supervision by a court officer. It is ordinarily recorded in narrative form, though the judge may adopt the question and answer format whenever necessary. The recorded evidence authenticated by the judge's signature form an essential part of the judicial record and serves as the foundation for the administration of criminal justice.